Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with what happens if you go to a closing and the buyer goes back to the house and the seller has left some personal property items behind. What can you do? What can the buyer who now owns the house do with those personal property items? Well, it might not be what you think it is, so please stay tuned to the end for some tips, points of practice for you as an agent to avoid this situation. So, in the RE Forms contract, it doesn't even address a seller leaving or taking personal property items with them. In the GAR Contract package, however, Georgia Association of Realtors, there is the exhibit, the seller's property disclosure exhibit, and that is GAR Form F301. Well, even let me back up for that. In the purchase and sale agreement in and of itself, and from this point forward, I'm just going to talk about the Georgia Association of Realtors contract, Form F201, under the paragraph C3, the title of the paragraph is Risk of Damage to Property. But in that paragraph, it does specifically state, at time of possession, seller shall deliver the property clean and free of trash, debris, and personal property of the seller not identified as remaining with the property. So where does the seller identify personal property remaining with the property? Well, that would be addressed in the GAR Form F601, Seller's Property Disclosure Form. And under paragraph D of that, under the fixtures checklist, it goes on to say there's a place where the seller indicates what personal property items the seller is taking when they leave and what personal property items they are leaving with the property. It goes on to say, items identified as remaining with the property shall mean those specific items as they existed in the property as of the offer date. No such item shall be removed from the property unless it is broken or destroyed. In the event such item is removed, it shall be replaced with substantially identical item if reasonably available. If not, it shall be replaced with something in a better, but that's not what I wanted to read to you. What I wanted to read to you is seller shall remove all items left blank below, and again, referencing this list, prior to closing or the transfer of possession, whichever is later. Seller shall lose the right to remove those items not timely removed, but shall remain liable for the cost of the buyer having to dispose of such items, provided that the buyer disposes of the items within 30 days after closing. Okay. So on one hand, you're saying, okay, Dana, the seller says they're going to get whatever out. If they leave something in the property, the contract says it now belongs to the buyer. And it is up to the buyer to dispose of that or keep it or sell it or whatever. Not necessarily the case. Is it, so we've got three things going on here. Is it based on, can we rely solely on that contract? That's number one, in which case the buyer who now owns the property does have the right to do whatever. Those personal property items now belong to the buyer, and if the buyer does have to dispose of them and incurs a cost, can charge the seller. Or are those items considered abandoned property where, same thing, the seller can do whatever they want with them? Or number three, the buyer. Or number three, if the buyer who now owns the property takes those personal property items and sells them, uses them, or destroys them, is that considered theft by conversion? Well, what is theft by conversion? According to Georgia law, Theft by conversion is when you lawfully obtain another person's money or property and then unlawfully convert it to your own use. Theft by conversion is also applicable to rental property that you fail to return to its owner upon demand. So the question is, what do you do? What happens? Do those personal property items belong to the owner, the new owner who is the buyer? Does the new owner, can they use them, dispose of them, sell them? If they do incur costs, like having to move a pool table or something like that, can they then go charge the seller with the fee for doing that? Or do they have to go file an eviction notice for the personal property items? Is it theft by conversion? And you're thinking, well, gosh, Dana, the contract says this. Well, let me tell you what the GAR contract further goes on to say. The GAR contract, the purchase and sale agreement, further goes on to say, under paragraph C4G, GAR forms, GAR, Georgia Association of Realtors, in and of themselves, go on to state, I had to move locations because I had to plug in my computer, but I wanted to point out to you that the GAR contract, yes, it does state that those items belong to the buyer who is the new owner. However, the GAR contract goes on to state that under the GAR forms paragraph C4G, it goes on to state that provisions in the GAR forms are subject to differing interpretations by our courts other than what the parties may have intended. At times, our courts may strike down or not enforce provisions in our GAR forms as written. No representation is made by GAR in the GAR forms will protect the interests of any particular party or will be fit for any specific purpose. What does all that mean? Well, what that means is I'm going to give you a couple of points of practice for you guys as agents. But there are many reasons why a seller might leave some personal property items in a house. They could do it because they didn't want to move it. Let's say there is a big, huge slate pool table in the basement, and they found out that it was going to cost more money for the movers to move it than just to buy a new pool table. So they decide to leave it and say, here you go, it's a welcoming gift. Welcome home, buyers. Here's your new home. Here's our gift to you, a new pool table. Buyers say, I don't want a pool table. I wanted the space. So they could have left it intentionally because they didn't want to move it. It could be that something happened with movers. Movers got rescheduled. If closing got changed, whatever. And they couldn't get movers to actually just move this stuff out at time. It could be that they ran out of time. They ran out of money. They forgot. It could be they had every intention of coming back later and something happened. It could be they just said, we're seeing you. We don't know necessarily the circumstances why a seller would leave personal property items in a house. We don't necessarily know if they were left intentionally or accidentally, if there was an intent for the seller to come back and get them. And that brings up a whole nother issue. If the seller does come back and get them, are they now considered trespassing on the property that's no longer theirs? Whole slate of issues. And here are some points of practice for you guys as agents to try and avoid this issue and having to deal with it. Number one, you buyers, agents, you want to schedule your walkthroughs hours before closing. You will want to do a walkthrough. You want to do really 2 walkthroughs. One, you will want to do a few hours before closing, especially if it is the house is supposed to be vacant. But you want to do it before possession. I'll put it that way. But really before closing also. But you also want to do it a number of days prior to closing. So if you go and do a walkthrough, if the buyer's buying a house and they go and do a walkthrough 3 days, 4 days, 5 days prior to closing, and you see a whole house full of furniture that hasn't even started to be packed up, that's going to prompt a conversation. Well, have you hired movers? Are the movers packing you as well as moving everything? I don't see anything packed up. What's kind of going on? Are you really going to be out? That will prompt a conversation, and then perhaps buyer and seller can negotiate some sort of an amendment to address that issue before it's a crisis level issue. So definitely you'll want to do a walkthrough in advance, well in advance of closing, so you can get a sense of where the seller is in packing and make plans for that. Secondly, you will want to reach out, and especially if a closing date has gotten changed. A variety of reasons that closing dates get changed. They get changed by amendment. In the GAR contract, they get changed unilaterally. That can also throw a monkey wrench in moving plans. If it is a domino deal and back-to-back-to-back deals, then that can also throw a wrench into moving plans. If you are closing at the end of the month where there is a holiday coming up, such as Labor Day, Memorial Day, so forth and so on, there can be a dearth of moving companies, and the seller could just have a hard time finding a moving company, finding friends to help them move. There's a whole variety of issues. So you'll want to reach out and have an understanding about when the seller will vacate the home prior to closing or prior to whatever possession date that is agreed to. And you will want to be able to demonstrate that you get agreement in writing between the buyer and the seller. No phone conversations, no email conversations between agents. Well, you should have those, but you need to follow up with an amendment to the contract in writing what the plans are. If you have to go to litigation or go to magistrate's court, that is going to give your lawyer a leg, the buyer and seller's lawyer, a leg to stand on regarding communication of their intent with regards to those personal property items. And last but not least, before you as an agent, after closing, if your buyer calls you, they go back to the house and all that stuff is there, you are not in a position to advise the buyer what to do with those personal property items. At that point, you really do need to advise the buyer who now owns the house that perhaps has personal property items in there that were not theirs or they were not anticipating. They really do need to reach out and get some legal advice and contact an attorney so that they can get legal advice based on the whole series of circumstances in the contract and what has been agreed to. Is that considered abandoned property? Do those personal property items now belong to the buyer who is the new owner? Or if the buyer does dispose of them, sells them, or uses them, is that considered a theft by conversion here in Georgia? So just some food for thought of an issue that can be quite complicated and is above and beyond the scope of your license as a real estate agent and the scope of any real estate broker's license within the purview of their being a real estate broker. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Bye. If you like that video, check out the one here. If you like the content on this entire channel, please click here to subscribe. I try to take even the most complicated of real estate situations and make them crystal clear. See what I did there? Real estate made crystal clear. Thank you guys so much for watching.